Hi, welcome to another episode of Kidon, War Stories on the Cutting Edge of IP Monetization. My name is David L. Cohen, and I am the owner of Kidon IP, a consultancy, and David L. Cohen PC, a law firm, where we provide IP monetization services to clients both large and small. Every episode, I interview other subject matter experts and leaders in the wide world of prosecuting, asserting, analyzing, monetizing, and defending intellectual property rights. You can find this show on YouTube, LinkedIn, Apple Podcasts, Google Podcasts, Stitcher, Spotify, and many more. Today, my guest is David Wanetick, the CEO of Incremental Advantage LLC. David has valued thousands of patents for Fortune 100 companies, startups, mid-sized companies, university technology transfer offices, national laboratories, and hedge funds. David is active in monetizing patents. He's the managing director at JD Merit, and he developed and runs the Certified Patent Valuation Analyst designation. The CPVA for short program has been run all over the world for more than 12 years. Some 250 testimonials are available on the website. David is the author of 7 books, including The Plight of the Patentee, The Case for Restoring Inventors' Rights, Solution Nation, One Nation is Disproportionately Responding to the World's Most Intractable Problems, The Strategic Negotiator, a manual for negotiating at the elite level, and Business Model Valuation, What Makes Business Models Work. So now that I've sung your praises, David, and your head barely fits in the screen, let's talk a little bit about what you do. So first, I like to situate my guests a little bit in their sort of the arc of their life story. So how did you get into, the elevator version, or you can decide if it's a 2-story building or the Empire State Building, the elevator version of how you got to where you are today. How did you get into patent valuation?
Well, thank you very much for having me as a guest, David. Really happy to be here. So I began my career as a Wall Street analyst. So I analyzed special situation companies, which is a very diverse portfolio. But I learned how to value companies in many, many different industries. So from the beginning of my career, I had a strong background in analysis of companies and valuation. I also had a side business, which was to develop conferences. And one of the themes that we ran for our conferences was intellectual property due diligence. And so we were very fortunate. We had excellent speakers come to speak to us. This is back some years ago. But we had the former commissioner of the USPTO and, very high-powered patent managers and licensing professionals from Fortune 100 companies spoke. So as I was developing my conference business and running these intellectual property conferences, I was learning a lot from the speakers, taking good notes, asking follow-up questions, and this went on for some years. So basically, I fused my background in traditional valuation analysis of private companies, public companies, and then learned a lot about intellectual property through the conferences and developed a patent valuation practice.
Cool. Do you have a background in engineering, or is it just in finance?
In finance. Well, when you do valuation, you need to know a lot about finance valuation. You need to know a lot about patent law and the process of patenting. Nobody knows every technology, but you have to know how to analyze the different technologies. You have to be a good interviewer. You have to make good use of the time you have with the inventors, the management teams of companies. And you have to boil down the report in such a way that it's readable for somebody else on the other side of the negotiating table who may not be an expert in that field. Licensing professionals, lawyers, they can't be an expert in every single technology.
No, I sympathize with you. It's not a criticism. I come to this field by way of the history of science and technology, and so I'm not an engineer myself. And I find, if I can understand it, then many other people can. I used to tell my interviewees, explain it to me like you're explaining it to your grandma, and that's usually gets them to break it down simple enough. So that's really fascinating. So and you're based but where are you based?
I live in Chandler, Arizona, and work in Chandler.
Oh wow!
Yeah. It's a big semiconductor.
And so your clients are, yes, it is indeed. Awesome. So let's get into the substance here. So patents are a strange beast, right? They're the right to sue someone in court, and so there's so many contingencies heaped upon contingencies about getting to actual dollars in forcing someone to give you actual dollars, that it always made my head scratch. How do you assign a value to the patent? You just get a patent. How do you assign a value to it? And so maybe you could break it down a little bit. Like, what kind of values do patents have, and how do you go about thinking about it?
Yeah, so just so the listener understands, most of my valuation work is not focused on assertion issues. Most of the valuation reports that I write are in the context of contemplated transactions. So usually it's the patentee that hires us rather than the potential buyer or potential licensee. And that patentee hires us because they're about to negotiate a capital raise, or they want to sell their patent portfolio or license out their patent portfolio or sell their company or a division of their company. So they're about to do a transaction, and they feel that if they have a valuation report written, it will help them in negotiations, because typically the patentee is outgunned by the other side of the table. Oftentimes patentees, even from mid-sized companies, they don't have a full-time IP asset manager. They don't have a licensing person. They may have a lawyer, but that lawyer may have done the last licensing deal 8 years ago. So they're not as well prepared as a very large company that has professionals in place that negotiate these types of deals all the time. So the report articulates a value that the patent portfolio, we believe, has, and the reports that we write are very lengthy. They're very methodical. They can be more than 100, 200 pages in length. So a lot of great research is produced, and that report can almost be used as a negotiating tool during the course of discussions with the other side. So patent valuation is a huge issue. I teach a 2.5-day course with a certified patent valuation analyst, how one values patents. I think the first thing to understand
David,
is
just to pause for a second. So to make sure I understand, and I wasn't implying that patents only are head scratchers in the context of litigation, but so most of your clients, they're coming to you just with a portfolio for valuation. In other words, just purely the legal instrument granted by the patent offices around the world, or are other things included in the valuation process typically, or both?
Yeah, so it depends on what the client has and what they want valued and what they're trying to achieve. So it could be anything from valuing one provisional patent to valuing a portfolio that may have 500 patent filings in it. Maybe there's only 20 families, a lot of sibling patents all over the world, lots of continuations and divisionals and so forth, and some applications and what have you. So it can be that. It can be the patent portfolio plus other things like trade secrets, trademarks, copyrights, software, and so on. Or it can be of the whole company. So it depends what the client wants to do and what they have. But we're capable of valuing anything along the spectrum like that.
Awesome. So I think I cut you off. You're on a roll here. So, given the various contexts in which so one of my hobby horses is that the value of a patent is extremely context dependent, and so I'm curious how you go about thinking, ascertaining the value of a patent, based on the various situations you've described. But of course, there's lots of other variables as well.
Right. Yeah, maybe before I do that, if you don't mind, I just want to articulate different kinds of value that a patent can have, because that might
No, that's an excellent bridge. Yes.
So, there's a lot of things you can do with a patent. You can sell the patent, you can license the patent, you can assert the patent, you can use the patent to countersue and neutralize litigation. You can use a patent as collateral to borrow money. There is some of that going on about twice a year. I have that type of situation. You can use a patent to try to achieve a standard. For example, Tesla said that they will make their patents grant license-free royalties to people that want to use their patents to develop charging stations. So you can make your patents available and try to grow another part of your business. Basically what Tesla's trying to do with this is have other people develop charging stations, so they'll have to develop less if they're interoperable, and that will make the electric vehicles even more common and popular. There's very different uses of patents. For example, if there's a trade dispute, let's say that the United States has an embargo and is not allowing any products from Huawei into the United States. So Huawei can't sell anything in the United States, but if they have a patent, they can still enforce their patents and derive some money from the United States.
Yeah.
So there's issues like that.
As T-Mobile learned to their chagrin, I guess.
Yeah, right. So anyway, there's lots of different values patents can have. It's a branding tool. Mercedes-Benz has commercials that boast about the size of their patent portfolio as evidence of their technological prowess.
Apple has a huge machine of people that they follow every single filing that they do. Get a lot of PR from that. Yeah. So.
Right. And a patent can make it easier to raise capital. So a lot of venture capitalists don't understand a whole lot about patents, but they say that a milestone is you have to get a patent issued, or they just won't talk to a company that doesn't have a patent. So one of the interesting things about patent valuation is that in litigation it's very hard to assert a patent, and there's not a really big vibrant market for trading patents. The auctions have pretty much gone away, and there's only a limited number of quality patent brokers. It's a difficult business selling, one patent or a small patent portfolio at a time. And usually the best patent brokers don't want to see a patent unless there's assertion potential. So having a great invention, a brilliant idea, very well drafted patent, sometimes doesn't yield a lot of value. But the other way of looking at it is every day, early stage companies get acquired for significant sums of money, many tens of millions or hundreds of millions or even billions of dollars. Well, if you look at that real life transaction that's very recent, it could be today. Why is that acquirer paying $100 million for an early stage company? What does the early stage company have? Well, it probably doesn't have revenues. It doesn't have profits. It doesn't have a lot of physical assets. The situation might be all they have is a good idea, a good management team, and a good patent portfolio. So if you do the apportionment on that $100 million acquisition announced today, where's the value going to go? It can only go to the assets the company has. Some of it will go to management. They may have a little bit in the way of physical assets, but another big bucket that deserves apportionment is the patent portfolio. So you look at it that way, some patents have quite a bit of value. The acquirer probably would not have been interested in acquiring a business or an idea or a technology that wasn't protected.
So I always tell my clients that, when you have a business where you're not making that much revenue, you don't have that many physical assets yet, right? You hope for it, but you have a lot of intellectual capital, right? And a lot of intellectual assets that are in the form of know-how or processes or things of that nature, trade secrets. It's really hard for investors who have, not a big attention span. I was going to say the attention of a flea, but I won't say that. For them to get a grip on what exactly you're having to invest in. And hi, David. So before I teleported to another location with better internet connectivity, we were talking about the value or the importance of patents in a context that's outside of a litigation context. And we're talking about assigning value or why instances of value or potential value for investors or third parties on a patent when there's no litigation planned. And one of the things that we were talking about, and I think I was asking one of my lead-up questions to try to try to get you to say something fascinating, um, was that when I tell my clients that they have, if you have a business, whatever the context, startup or even M&A, that's very much know-how focused and very much doing things focused and intellectual capital rich, it's very hard for third parties to assign a value, very hard for third parties to even write a contract about that business without something concrete. And the role patents often play is what I, at least in my understanding of these things, is sort of a stake in the ground. Even if the patent isn't very good as, and I never said this, but even if the patent is never very good as a legal instrument to enforce in court, the mere fact that it articulates something about technology that was relevant to this sort of know-how, which could be tacit knowledge of the employees or whatever, allows people to contract around, create licenses about, create tech transfer agreements, to create valuation reports about this business that people are trying to do economic transactions with. And so, I that's how I always view it. And I think we're saying the same thing, but coming at it from different angles. But maybe having said that, maybe you can expand a little bit more about patent value in this context, in this non-assertion context. Um, maybe you can expand on that.
Yeah, so for companies and institutions to do business together, they need to talk about money, and they need to determine ownership of new entities that are formed, ownership of joint ventures that are formed. They need to talk about the contribution of value that a university contributes to a spin-off company. You need to talk about the value of an emerging company that's seeking venture capital financing. So you have to take something that's somewhat abstract in a general sense and put a value on it to consummate transactions. So the process is long and difficult. It's not easy to value patents. There's many different financial methodologies that can be employed. Everything from the basic ones, the primary ones like the cost, market, and income method. But under the umbrella of the market method, for instance, there's many permutations. You can look at comparable patent transactions. You can look at venture capital financing and try to understand what the VCs are implicitly valuing patents at other companies and using that as a gauge to value your company. You can look at acquisitions. You can look at the different multiples patent-rich companies receive versus companies that don't have many patents in the same industry, and apply that multiple and the cash flows to your situation. And then there's more elaborate methods that are more difficult to apply, like Monte Carlo, real options, binomial lattices, Nash bargaining solution, Markov chains if it's a larger patent portfolio. So there's a lot of methodologies to apply, but one also has to understand the patents themselves. Not only the economic import of them, and you have to discount the value that you obtain by applying these methodologies by the quality of the patents. There's always an invalidity risk. No matter how well the patent was drafted, there is almost always an invalidity risk. So maybe I'll just mention a couple of things that one can look for as far as the patents themselves, because a lot of times companies go to investment banks or go to accounting firms to have a valuation done, but these people rarely delve deeply into the patents themselves. So, of course, you want the claims to read on an important technology, a unique technology that has potential in the marketplace or is already successful in the marketplace. You want those claims well drafted and well supported. You would like to see very rigorous prior art searching having been conducted already, ideally with different technologies such as latent semantic analysis and Boolean technology. You would prefer that several firms have been hired to do patent searches. You would prefer that the inventor knows the space extremely well. You would prefer that synonyms are checked and trade names and so forth are checked in. in the prior art searches. You want there to be a very clean chain of title. The fewer the transferences of the chain of title, the better. You can look at forward citation analysis, and we have a ratio that looks at the recency of the patent having been published. How long ago was the patent published relative to the amount of forward citations the company has received, the patent has received. The idea is the less time the patent has been published, the less forward citations you can expect it to have received. But the longer it's been published, the more forward citations it should have been received. You look at the quality of people making those forward citations. You would prefer it's coming from big companies that have the power to do a licensing deal versus a sole researcher somewhere in Eastern Europe, for example. You like there to be a concentration of those forward citations by the big companies. As far as backward citation, oftentimes the more technologies that are backward cited, and the same with inventors, the more diverse the inventors' academic backgrounds are, the more likely it is that many different ideas were incorporated into the patent, many different disciplines were woven into the patent. Therefore, it may be applicable to more industries. So there's more optionality potential with that. You can look at the patent prosecution process relative to things like the obsolescence rate. So if you're looking at a technology that obsoletes very, very quickly, let's say software, maybe accountants would say that there's a 3-year amortization of software. Well, if it took 12 years to get that software patent, the technology theoretically could have obsoleted itself 4 times before a patent issued. It's even
I
worse.
imagine there's a lot of, the various methodologies that you've been talking about, are various things to nice to have. You have a lot of rules of thumb that you've created based on the technology space or based on the business structure that you've generated, sort of just like what you mentioned. And, like one of the rules of thumb that I say from a patent assertion perspective is patents just don't achieve their value in the marketplace as an assertion instrument until like 7 to 10 years into their life, because it takes a while for the market to catch up, to the extent it ever does catch up with the value of the patent, for there to be an assertion program worth doing. And I wonder, are there other sort of key things that you look for, or are these, or now we're approaching into David's trade secrets that he can't share?
Well, actually, I published quite a few articles, and one of the articles I published, it's kind of funny, but I documented, I think, pretty well, was comparing the value of a patent over time to the value of a professional baseball player's career over time. So,
okay.
Typically, both patents and baseball players are not worth so much in the very, very beginning. Because there's a risk of invalidity challenges and so forth, and it just takes time to prove out different technologies. So I think my conclusion was the patents are most valuable from 3 or 4 years to like 7 or 8 years, something like that. That's a good sweet spot. After 7 or 8 years, a lot of other things deserve apportionment. So you go back to that emerging company. Initially, it doesn't have much else besides people and patents. And so there's risk that the patent could be invalidated early on, or there's no product in the market the first couple of years. Then the product goes to market. Hopefully it grows and generates more and more revenue. But after 7 or 8 years, that company has other things that deserve apportionment, such as financing or customer service or reputation or a call center or built-in customers or contracts and things like that. So anyway, it's kind of a fun article that is available.
No, but it's fascinating, and it goes back to my point of the contextual analysis. I totally see your point as to the value of the patented technology to the company that owns the patent being in that time frame that you mentioned. And I was talking more other competitor, assuming that this was an early stage a patent, in that it was early stage the ultimate technology. So it's, I hate to use the word groundbreaking, but highly relevant to the technology. It's not really implemented in the marketplace on a wide scale, such that the patent owner has lots of competitors until 10, 11, 12, 13 years in, when now, as an outside investor, you can say, all right, well, this patent can be used to sue the crap out of people. Pardon my language, but it's a different context of the use, and I imagine that how you want to use, and that was always my question to people who want patent valuation, even if I don't do it, is what is the intended purpose of this valuation, because that's going to really drive how you go about the analysis. And I'm curious if you see it the same way, and how you would go about thinking the relevance of the intended use into the valuation process.
Right. So that's one of the first questions I ask a prospective client. Why do you want your patents valued? If it is assertion related, then you don't have as much freedom in the way you prepare the analysis. You want to make sure that it would survive a Daubert challenge. You want to make sure it adheres to precedent. You have to use the tools that you're supposed to use. So you have to focus on reasonable royalties, and you have to know about what are the limits. You have to apply the Georgia Pacific factors. If you're eligible to pursue lost profits, there's procedures that you have to apply to calculate lost profits. When it comes to negotiating a friendly deal, an investor wants to invest, a patentee needs capital. They want to do the deal together. They want it to be fair, but they don't know how to value the investment, how to value the patent portfolio. So you really do need to understand the context of this. Sometimes, oftentimes the patentee has an exaggerated sense of what the patents are worth, and you need to.
I have to just say, my usual line is, I think I've met 1,000 people who've invented the best thing since sliced bread. I'm sure you too.
Yeah. Well, just a funny thing to say about that is 90% of the patents are not in the top 10%.
Yes.
So sometimes you have to not take on engagements. If the potential client has wildly exaggerated expectations and is not going to be happy with the report, sometimes you just have to decline that.
Yes.
Another thing that we do is, we usually have a check-in point halfway through the engagement. So I've done a lot of the research, a lot of the modeling. We have a call, and I tell the client what number I'm at. If the client, thinks the number should be 10 times higher, or, much, much higher than what I have, then, I can say, well, we could cease the engagement at this point. We could terminate the engagement at this point. I already received half of the fee up front. So I was paid for half of the work. I did half of the work and did a lot of the analysis. I came up with a conclusion of value. Obviously you're not happy with it. You probably don't want the report. So why don't we just stop the engagement here? You don't pay the second half of the fee. I won't deliver the report. We'll just end it here, and you won't have a report with what you think is a lower number in your files. And we can just stop at that point. So that's one way for handling clients like that.
Oh, definitely. I think that of course, speaks to a risk that we all face as service professionals providing advice in a regulated environment, which is that you can't choose the clients that come in your door, but you can choose which ones you engage in, or you continue to engage in, or at least you hope to. And I can only imagine some of the wild-eyed people that come across your desk.
Most of them are fairly reasonable. A lot of them say, I really want to know. I really want to know what the real value is. You do filter. Sometimes you look at the referral source. So if the referral source is, a quality investment bank, an accounting firm, a quality law firm, then that's a good signal. Number one, indicates they can pay what you need to charge, and it indicates that they have been coached to some extent. And then sometimes you just have to explain to them that the report has to be credible. You have to be able to back up the number, otherwise it's not worth anything, and you're wasting your money and wasting my time. And you have to explain to them that if you come up with a very high number that's not deserved, they're not going to be able to find an intermediary to represent them. they're not going to be able to define an investment bank or patent broker, because those intermediaries know where the market is, and they know they're not going to make the client happy, and most of their income is from success fees, and that the client's not going to close the deal because they think they deserve 10 times more. So you're not going to be able to attract an intermediary, and you're not going to attract a venture capitalist or an acquirer, or they're not going to waste their time talking to somebody whose expectations are in a different stratosphere. So you have to explain those kinds of things. And
Yeah, no,
sometimes,
unfortunately, I've come across too many of these valuation reports that I guess the guy was either he believed the Kool-Aid, or he or she believed the Kool-Aid, or they were unscrupulous enough to take however much money they take to get these unwarranted stratospheric evaluations. But moving along from sort of difficult clients to sort of more of the mechanics of it, I've looked at some of your reports that you kindly sent over, some sample reports, and they're pretty long, as you mentioned. So I imagine that, I mean, of course, I'm sure there's templates and you have processes and things off the shelf, as it were, but I imagine it takes a long time to put together. And maybe you can, obviously don't give me your prices, but give me, if you can give some sort of way that potential clients could think about, how long will it take from point A to point B, and also how much is it going to cost them or set them back, generally speaking? How would they go about getting a sense of, David's a bargain, or David's pricey but great, or something else?
yeah. Of course, the quote depends on the portfolio. What exactly is being valued? Is it just the patents, or also trade secrets, trademarks, whatever? The scope of the patent portfolio, is it one provision, or is it 500 patent filings all over the world? Generally, we ask for 6 to 8 weeks to prepare the report. Again, if it's less complicated, maybe a little faster; more complicated, maybe more time. There really is no cookie cutter. At least I haven't found it. It's very, very labor intensive preparing these reports. You have to understand very complex technologies, at least not as well as the inventor, but at least well enough that you can anticipate how it will fare in the marketplace. Lots of financial models are developed. All these patent-specific issues are addressed, and so anyway, about 6 to 8 weeks to prepare, at least for me. And the price, of course, varies. It could be all the way up to $150,000, but more typically, for a relatively small portfolio, it could be 20 to 25,000, depends. But that's usually the starting point.
That's, by the way, that's the ballpark that I've seen from reputable evaluation experts that I haven't come across all different use cases. So that's, for our listeners out there, that's totally reasonable.
Yeah, you go to an accounting firm or an investment bank, it's typically likely to be 2 or 3 times as expensive. Yes. And we have to make sure these people really understand this patent specific issues.
You're paying for the wood paneling, that's why.
Yeah, a lot of it's the name and so forth. But anyway, just so everyone knows, we talked about some of the patent specific issues we addressed. We developed something called the patent valuation gauntlet, which consists of about 900 questions that can be asked relative to patents. Very, very specific things. So, of course, we don't ask every question to every patent filing, but there's a long list of considerations one might want to apply to the patents themselves, beyond what they do with the financial modeling.
Right. Well, that's the kind of thing I was getting at, as sort of off the shelf. Not that you have off the shelf text, but that you have standardized processes. I come from technical standards, so I like standardized processes because it just keeps you honest. You have to deviate every once in a while, but it sounds like you have a pretty standardized process that you run the question, the thing that you're valuing through, and obviously it takes a lot of work to do that, and it definitely shows in the reports that I've seen. So actually, speaking of which, I think one of the things you mentioned, that there's a way for our people want to know what they're getting into, especially put it differently. One of the hazards that people like us have is we encounter patent owners, patent portfolios every day of the week, right? That's what we
Right.
do. But most of our customers have just one, not necessarily one patent, but one portfolio or one small group of patents. And so they haven't been through our gauntlet that we live. And so they want to, what's obvious to us and what seems normal to us is totally brand new to them. So how would how would the listeners out there in the interwebs get a sense of what's involved and what's the output of a David Wanetick report?
Well, they can contact me and we can send them a older genericized sample report. So they can contact me on LinkedIn or send me an email at dwanetick@incrementaladvantage.com. We have about 15 articles published on another website called Patent Fairness Opinions. So I mentioned the one comparing baseball players' careers to patent life and value. So they can go to patentfairnessopinions.com and read articles there. We have Patent Valuation Gauntlet. The website's patentvaluationgauntlet.com. That discusses the 900 metrics that we apply. We run a course, Certified Patent Valuation Analyst designation. They can attend that and learn about all the nuances of valuing patents.
David, if you after the video ends, if you can send me those links, I'll put them in the blurb that'll accompany the video.
Okay.
So that's great to know. That's very, very, very useful. Maybe just switch. I think it's hard to give a whole course, especially in this kind of format here. So I think we've covered a lot of what you do, and unless there's something you feel is missing. But the one thing I wanted to briefly discuss is the CPVA program that you created and what that's all about. But before I do, is there anything else you wanted to say about your sort of day job as a patent valuation expert?
Maybe I'll just talk about a couple of interesting metrics that are not that common, just because I want to give something of value to your listeners. So one thing about prosecution is you want to see if the patent filing, the patent application, falls between two different art units. For example, if we have an invention on 3D printing of kidneys, the examiner probably is either going to be an expert on 3D printing or nephrology. And right. The risk is that they may not do a good patent art search on the field that they're not an expert in. So if you have a patent that falls between two art units, there's a risk that the prior art searching, that part of the examination may not be as good as it can be. Now, just something else that's sort of not so well known is you have to realize that sometimes at a large company, the director of sales has a veto over assertion. So you might look at a big company, let's just say IBM, and somebody at IBM may tell their corporate counselors that we know that a big automaker is infringing our patents, and the process there might, a company like that might be that, well, first we have to run it by the director of sales before we start asserting our patents against a huge client. And the director of sales is going to say, no, you're not going to start an assertion against this client. I'm trying to sell $200 million of computers. I don't care about your little patent. So you're not going to assert it. So that's a problem. We're talking about some of the negative things, unfortunately. But another, I wrote a book called Plight of the Patentee. It talks about a lot of the hardships of patentees. Unfortunately, one of the other things is that a lot of times one's own venture capitalists won't allow them to assert their patents because if you have a routing technology, internet, device. You are funded by a VC that funds those kinds of companies. They want to have their companies make exits. The exits are going to be selling their portfolio to companies like Cisco. And if one of their portfolio companies starts litigation against Cisco, that may cause problems for the whole VC. For all the portfolio companies, VC might say, don't do that because we got to sell 8 companies to companies like Cisco. So, there are those real world like situations that have to be considered.
No, that's very, very true. I resemble that remark about IBM. I mean, obviously, I never worked at IBM, but I know that story very, very well from many, many companies that I worked in and I spoke to. So I can tell war stories, but I'm not sure if they're protected under various privileges or not. Be that as it may, so maybe in the few minutes we have left, you can talk a little bit about the CPVA program. Just give a. I know I did a course for you once on global patent litigation in the context of that program, but maybe just in like a minute or two, tell our listeners how that course came to be and what it's up to nowadays.
Yeah. So 15 or so years ago, we started running courses on patent valuation and negotiating licensing agreements and calculating damages when there's infringement and so on. And it took me a couple of years to figure out I should put these courses together and have a designation. So for about 12 years, we've been running the Certified Patent Valuation Analyst program. It's 2.5 days of training. The first day is solely on valuation. We go through many of the metrics that we spoke about and so on. We make all the models available to the attendees. We make the patent valuation gauntlet available to the attendees. So that's hardcore evaluation. The second day, the morning session, is on calculating damages that arise from infringement. So we go through Georgia Pacific factors and recent cases and so forth. We go through reasonable royalty damages, lost profit damages, entire market value rule, or smallest saleable unit issues. The second part of that day is on running a mock negotiation of a licensing transaction. That's a very interesting case study that we work through. And then the last part is a webinar consisting of 3 American lawyers talking about different aspects of the patent prosecution process, drafting patents, looking at different elements of patents, assessing them like claims, specifications, and so on. So that's the course. We've run it all over the world for 12 years. All over Europe, Israel, Dubai, Singapore many times. IPOS, the IP office of Singapore, is my partner in Singapore,
Wow.
China, Hong Kong, and we have a partner in France, a partner in Spain, partner in the UK, partner in
Are these
Israel.
courses all in English or?
Yeah, yes, except for China. My partner in China translates everything. So I speak in English and he interprets. But yeah, so we have hundreds and hundreds of testimonials. About 250 are on the cpva.info site. And then privacy laws came into being in places like California, Singapore, Europe. And so I was advised to stop putting people's emails on the website, as testimonials. So we stopped that about 5 years ago. But we have hundreds of testimonials and great partners. And typically the people that attend are patent professionals versus finance professionals. So we get a lot of patent lawyers, IP asset managers, licensing professionals, tech transfer people, some investors, some inventors. But yeah, it's very fun, very popular course, very intense. And hopefully the pandemic will continue to recede and it'll be easier to run live courses. It's been a very bad 2 years for that business. Terrible.
Yeah, no,
terrible
totally. Well,
years.
but to that end, send me a link and I'll put it in the blurb as well. Well, listen, David. I first of all, let me apologize for the technical gaps that we had, both to you and to the reader, which ate a little bit out of our time. But I trust we'll put a nice show together, and our readers will enjoy learning a little bit about patent valuation. And this has been a fun and scintillating conversation. And I'm sure our readers listening, our listeners listening, or our readers reading any transcript will have plenty of unanswered questions about patent valuation. I'm sure I do, but that was the point. If you want to know more, you know who to talk to. David Wanetick. All right. Thank you again.
Thank you. It's a real pleasure to be on your program. I appreciate it.
Excellent.